Hi everyone, I am Suhrit Krishna Subramaniam of St. Joseph's College of Law, and I'll be discussing about inheritance rights of women under different personal laws. A woman holds an important position in the Indian society. Yatra naryastu pujante ramante tatra devataha. This Sanskrit verse expresses that where women are worshipped, God resides there. When a woman is regarded so high by our scriptures, what is the real state of affairs? Let us now look at the inheritance rights of women under the various personal law. Hindu. Let us now delve into the evolution of inheritance laws over the years in Hinduism. Hindu women earlier had no right in the property of her ancestors, spouse, or children in the olden days. The inheritance of property was passed on to the son, who would be the successor of that property. The Hindu joint family was predominantly a male dominated society. Male was regarded as the family's leader. As a result, by virtue of their birth, male members of such a joint family were expected to inherit both property and wealth. It was challenging for the female heir. The law later recognized the Hindu woman's equal status to inherit property through the Hindu Succession Amendment Act of 2005. Does the daughter also have rights in the ancestral property? If so, does that make her eligible to have rights in the self acquired property of her father? Section 14 of the Hindu Succession Act of 1956 states that any property owned by a female Hindu is her absolute property, regardless of whether it was acquired before or after the Act came into effect. This includes both movable and immovable property. A Hindu woman has the same rights as a Hindu male towards her deceased parents' property. Under the Hindu Succession Act, women are considered as Class 1 legal heirs. Yes, the daughter does have rights in the ancestral property and also in the self acquired property of her father, irrespective of her marital status. This was ruled in the year 2005, where even Hindu women have equal co partnership rights. Section 6 of the Hindu Succession Act also talks about co partnership succession rights of the daughters. The inheritance laws in India are governed by the Hindu Succession Act of 1956 and it is applicable to all Hindus, Buddhists, Jains, and Sikhs. Many a times, mothers are ignored when it comes to the inheritance rights of the self acquired property of her son. A woman, being the mother, is entitled to an equal share as the wife and children of her son who has died intestate, which was passed in the Karnataka High Court by Justice H.P. Sandesh in the year 2023, where mothers were considered as Class 1 legal heirs. Any dispute which arises on the succession rights are to be dealt in the civil courts. Muslim. A Muslim is governed by the Muslim Personal Law Shariat Application Act of 1937. Muslim personal law in India is based on a combination of the Hanafi and the Shafi schools of law. The Hanafi school is the most prevalent and is followed by most Muslims in India. The evolution of property inheritance over the years. The share of inheritance rights of women is fixed in the Quran. In Islamic law, women's inheritance rights have evolved through historical interpretations and adjustments in different regions. Traditionally, Islamic inheritance law derived from the Quran and Hadith provided women with specific shares of property, which was groundbreaking compared to many other cultures where women had little or no inheritance rights. According to Islamic teachings, daughters inherit half of what sons receive, reflecting a division that is intended to balance the financial responsibilities within families. Are the daughters allowed to inherit their ancestral property and the self acquired property of a father? Under the Muslim personal law, there is no distinction between the ancestral and the self acquired property under the Muhammadan law. Daughters have become rightful legal heirs of their parents' estate, but a quantum of share of the female heir is half of that of what the male heirs receive. Daughters also have right to reside in the parental property after divorce or widowhood if she has no children. Is the wife entitled to a share in the property of her deceased husband? Yes, she is entitled to 1/8 share of her husband's property if the couple have children, or else she can inherit only 1/4 of that share. Christianity. Inheritance rights under the Indian Succession Act of 1925. The Indian Succession Act is the primary law governing the inheritance rights of Christians in India. It applies to all Christians regardless of denomination. Division of property. In case of intestate succession, the property is typically divided among the surviving family members, that is, the spouse, children, and other relatives, according to the specified shares. For Christians, the property is divided among the spouse and children. Under the Indian Succession Act, preference is given to the children rather than the parents. Only in absence of children, parents will be given inheritance rights. Gender equality in inheritance. Historically, women did not have equal inheritance rights, and practices were often governed by customs or local traditions. In certain communities, men were given a larger share and women's rights were limited. However, over time, the law has evolved to ensure gender equality in inheritance. Under the Indian Succession Act, both sons and daughters have equal rights to inherit from their parents. The law provides that if a Christian dies intestate, the property is divided equally among the children, both sons and daughters. The widow also has a share in the husband's property. Inheritance rights of women under the Indian personal law reflect progress towards gender equality, yet disparities persist. Thank you. For more such videos, please subscribe to our YouTube channel.